Students, let us discuss the last concept of this chapter, communication of special conditions in the contract. Let us highlight special conditions. The entire discussion is based on these special conditions. Now, you must have noticed that there will be a big sign of 50% off, but immediately after that, terms and conditions apply. So when can we say that these terms and conditions are properly communicated? So law has defined proper rules for it. So let us read and understand those provisions. Now these terms and conditions applied, they are mentioned. It is your duty to ask what are those terms and conditions. You need to find out and only then enter into a contract. So it is the duty of the buyer, it is the duty of the person to inquire about the terms and conditions. Otherwise, we will assume that it is properly communicated. So sometimes when we go to buy goods, you enter into contract. It is a very common, it is very common on the invoices, or it is very common on the advertisement. They always mention asterisk terms and conditions apply. Sometimes it is expressly written on the bill. It is written that the dry cleaners bill, we have discussed this example in standard form of contracts. The dry cleaner bill mentions the terms and conditions that we will not be responsible for loss of color. We will not be responsible if the zari goes black. We will not be responsible if the goods are not collected within 7 days time. Yes. So these terms and conditions are properly mentioned on the bill. So there are many terms and conditions. My only requirement, law only requires that these terms and conditions must be properly communicated to the other party, and the terms and conditions must be reasonable. All right. So let us discuss something more about these special terms. See, the terms may be either expressly communicated to the other party or they may be tacitly communicated. It is important to communicate. How will you communicate? You can either expressly communicate that, or the conditions may be tacitly communicated. Now, what is express communication? Have you ever been to an airline counter? Yes, I think you must have. So the person will always ask, sir, is there any power bank in your cabin baggage? Is there any power bank in the check-in baggage? So he will inquire whether there is any power bank in your check-in baggage. And he will, no, sir, please put it in your cabin baggage. The no liquids of more than 100 ml allowed in the cabin. So he will communicate all this to the customer. When he expressly communicates these conditions, this is known as express communication by the offerer to the offeree. Sometimes we assume that they are tacitly communicated. It means it is impliedly communicated. Like, see over here, they need not tell you the instructions separately. It is already mentioned in the standee. This is known as a standee. So you cannot miss it. Whenever you are standing in the queue, or it is placed at a very prominent position. It will be either displayed at the counter, or there are boards on top of it. So there it will be displayed. It will be either in the form of a standee. You are in the queue. You are bound to read it. This is tacit communication. We assume that you must have read these terms and conditions. Now, it had happened with me once. These terms and conditions were printed, okay? And it is a very common knowledge that scissors, knife, lighter, matchsticks, they are not allowed in the inside the aircraft. Now, it is properly printed. It is properly mentioned over there. They never come and tell you, because how many conditions they will inform you. Sometimes it is your duty to read because it is prominently displayed. Now, there was a very expensive pair of scissors in my pouch, and I was not even aware that I had kept the scissors in that pouch. I didn't remember actually. So it was prominently written, scissors not allowed, and sharp objects not allowed, matchsticks not allowed, gun not allowed, coconut is not allowed. Everything was written. Then when we reached the security check, my bag was scanned, and then he said, ma'am, please open your bag, open this pouch. And I had those pair of scissors. He said, you can't take this. I couldn't even tell him, like, please let me allow. Do I look like a terrorist? He's not going to make any exception for me. No, I lost a very expensive pair of scissors. And after that, I always check whether whether my pouch has scissors or any other item which are not allowed. So I couldn't argue because it was impliedly, it was tacitly communicated to me through those boards. So in that case, it was my error. So sometimes the conditions are expressly communicated and sometimes they are tacitly communicated by mentioning either such standees or displaying at the counter or on the top of the counter. So that is nothing but tacit communication. Can these conditions be deemed to have been communicated? Yes, you can assume that these conditions are properly communicated to the other party. It is your duty to read if it is prominently displayed. Can the offeree be treated to having accepted those conditions? If you don't object, it means you have accepted. See, you are not objecting. You just go to the ticket counter, you take the ticket, they scan your bags, etc. You have not objected. It means you have impliedly accepted those conditions. Like it was displayed. I did not argue. It means I am fully accepting that if there are scissors, bomb, coconut, chili powder, any spice in my bag, then that will be confiscated. It is assumed that I am aware, I have accepted those terms and conditions. Okay. So these are special conditions in the contract. Sometimes special conditions in the contract, they are conveyed tacitly. Tacitly means impliedly, silently they are communicated by the offerer. Acceptance is also conveyed by the offeree tacitly or without even him realizing. See, it was displayed. It is their duty to display it prominently. They did that. I did not object to it. I did not create any scene over there. And I did not ask any question. It means that I have accepted. Acha, it may happen that I was very busy playing a game on my mobile. I did not even read those conditions. But it is still assumed that because it is prominently displayed, I have accepted those conditions. I didn't even realize that it is implied acceptance. So sometimes we accept even without realizing. Documents like ticket, receipt, they contain conditions either on the face of it or on the back of it. Sometimes they are accepted even without protest. I mean, we don't even realize because we don't even bother to read what is written on the invoice. Have you ever checked what is written on the invoice? We don't do that. No, we go to the billing counter, we pay the money, he gives us a bill, we just put it in our bag. But it is our duty to read that bill carefully. Instructions may be displayed at the notice board of the airline's office, where passengers may have not even cared to read it. I think 90% of them don't even read. But even then, it is assumed that they have read it, they have accepted, they have no objection to it, they are accepting it without any protest. The question is, can we consider that these instructions have been properly communicated? Can the offeree be treated to have accepted those conditions? The answer is yes. We will assume that he has that it is properly communicated, and if he is not objecting, we assume that he has accepted those conditions. Answer is yes. Okay. This amounts to tacit acceptance, implied acceptance, silently. We have not objected, it means we have accepted. Even if those terms and conditions are not brought to the notice of the offeree. We have not asked, sir, please read it. It is displayed. We assume you have read it. Like in my example, if it is mentioned on the standee, no airport officer will come. Ma'am, did you read this? Please read. No, they will not tell us. It is displayed. It means you have read it, you have understood, you have accepted it. We will assume. Okay. Now there is a very interesting case law. Mukul Datta versus Indian Airlines. Now Mr. Mukul Datta had purchased a ticket from the airline counter. The counter prominently displayed the condition about carrying luggage on board. It was prominently mentioned. The ticket also carried those conditions, but it was in very fine print. In case of any issue, in case of any condition related to the carriage, who will be responsible? Tell me, Mukul Datta or the airlines? In this case, Mukul Datta is responsible because the airline had prominently displayed the conditions about carrying the luggage on board. If you have not objected, we will assume that you are aware, you have accepted those conditions. If there is any issue, you cannot blame the airlines if those conditions were properly communicated. So in this case, the court held that Mr. Mukul was bound by the condition since the airline had made an effort to communicate the same. May or may not be asked in the exam, but it's an important case law. So whenever the concept is asked, you need to mention at least the name of the case law. Okay, so please memorize the name. Name is important. If a question is asked on the concept, you need to write the name of the case. One very interesting case, I always hope that this is asked in the exam, but it is very rarely asked. Lily White Dry Cleaners versus Munnuswamy. Okay. Now, what happened in this case law? Lily White Dry Cleaners got Munnuswamy's sari, new sari, and blouse for dry cleaning. Okay, Munnuswamy gave her sari and blouse for dry cleaning. The sari costed 220 rupees. Okay, the cost of the sari was 220 rupees. The dry cleaners gave her an invoice, a bill, which clearly stated that in case of loss of clothes, Lily White Dry Cleaners will be liable only for 50% of the cost of the goods or 50% of the market price. Now in this case, they initially claimed that we lost your sari and blouse, but later the blouse was found, but the sari was lost. So she claimed the entire cost of 220 rupees. But the dry cleaners reminded her, Arey, you forgot about, we are liable only for 50%. We will pay you only 110 rupees. She said, but you have lost my brand new sari. I have worn it just once. You have to give me the entire price. So they said that we had clearly mentioned it in the invoice. You also accepted that invoice. So if you did not object, we will assume that you have accepted those conditions. We will pay only 110 rupees. Munnuswamy filed a case. But the name of the case law is not Munnuswamy versus Lily White Dry Cleaners. It is Lily White Dry Cleaners versus Munnuswamy. So it means that dry cleaners filed a case on her. Is it so? No. The original case was filed by Munnuswamy on the dry cleaners, but the dry cleaners were not happy with the judgment. So they filed a revised petition. They appealed. They said, no, we would like to appeal. They filed a revised petition. That is why it is Lily White Dry Cleaners versus Munnuswamy. So she is claiming the entire cost of the sari, but the dry cleaners, they are very adamant. They said, no, we will pay only 110 rupees. So you tell me whether she can recover the entire amount of 220 or she is entitled to only 110. Based on what we have discussed till now, I think your answer will be 110 only. But there is also one more requirement which we will discuss through this case law, that yes, law allows us to impose certain conditions. We also assume that if there is no objection, the other party has accepted those conditions. But law is also very clear that these conditions must be reasonable. What is reasonable? That is not defined in law. It depends on the facts and circumstances of the case. So it's not defined in law. Now, the judge was of the opinion that if the dry cleaners are allowed to give only 50% of the damage, it means that they will act very smart. They will always identify new clothes and then tell the customer, we lost it, pay 50%. It means they got a brand new cloth for 50% of the price. See, in this case also, they got a brand new sari at 50% of the price. They can sell this garment to someone else. So we are benefiting them through by writing such kind of unreasonable terms and conditions. We cannot allow that. So we cannot allow Lily White dry cleaners to cheat the customers and get, we don't know whether they are telling the truth, whether it is actually lost or whether they are lying. There's no way to verify that. How can we allow them to pay only 50% and get brand new clothes at 50% of the cost? So in this case, Munnuswamy won the case and she was entitled to the entire price of 220 rupees for her sari. The law is very clear, students, and I think it does not favor any party. It is very neutral. Lily White, R. Munnuswamy gave a brand new sari and blouse for dry cleaning. Okay, brand new sari. The sari was, however, lost due to the negligence of the dry cleaners. She filed a case for recovering the full price. The price was rupees 220. But they reminded her that on the reverse side of the bill, it was clearly mentioned that in case of loss, the customer is entitled to only 50% of the market price or the value of the article. Here it is the value of the article. So 220, that is 50%, comes to 110. So either 50% of the market price or the cost. So here the value is 220. So she is entitled to 110, but she was unhappy with this. She filed a case. It was held that the customer is not bound by this condition because it means that the dry cleaner can now purchase the garments at 50% of the price. This was an excellent observation of the court. If this condition is enforced, any dry cleaner or any laundry owner will try to misappropriate new clothes and they will pay only 50% price for it. Such condition was unreasonable. Okay, it was opposed to public policy. Write on the meaning of public policy. Public policy means society. We cannot allow such unethical businesses to flourish in our society. This is against the well-being of people. It is against the well-being of the society. Therefore, it could not bind the parties. Any term which is prima facie, write down the meaning of prima facie. Prima facie means first impression. First impression. So any term which is prima facie opposed to public, means it appears to be opposed to public policy. Prima facie means first impression. And it is opposed to the fundamental principles of the law of contract that cannot be imposed. It cannot be enforced by law. Simply because it was printed on the reverse, there is tacit acceptance. We cannot allow that. See, law is not like maths, which applies to every situation as it is. One mathematical formula will apply to every sum which is of a similar kind. Law is not like maths. Law depends on the facts, the circumstances of each case. So over here, it appears to be against the society. It appears that the dry cleaners is cheating them and asking them to bear only, by telling them, I will pay only 50% of the cost. So in this case, you cannot enforce it simply because, no, see, you have written, we have printed it. Law, you had only mentioned that if I print, then these conditions are binding in the contract. But that condition itself is unreasonable. You shouldn't have written that in the bill in the first place. There is no tacit acceptance when the bill was received by the customer. So don't argue with the court because they are very clear that simply because it is printed doesn't mean that it is tacit acceptance when the bill was received by the customer. The term which was printed, that itself is unreasonable. It is not enforceable by law. So a very interesting case law. And I think that you should at least learn the name of the case law. You can write the facts in your own words. Don't go very deep into the concept and explain everything in detail. It is not required in the exam. What you need to learn are these 3 bullet points. If you learn them properly and if you just write the name of the case law, I think that should be sufficient. The terms must be reasonable. Okay, the case law which is discussed is Lily White Dry Cleaners versus Munnuswamy. You need to learn the name. Please also pay attention to the spelling. You cannot make a mistake in the spelling of the case law. The spellings are to be perfect. What is reasonable? It is not defined in law. If we find that the terms are unreasonable, then the other party will not be bound by those conditions, even though they are mentioned on the bill, even though he did not object. Still, because the terms are unreasonable, it will not be binding on the offeree. So yes, the other party is not bound by those conditions. And students, with this, we come to an end of the chapter. Now, in my next session, I will be discussing the question answers with you. But, I have a small question to ask you. I wanted to ask that at the beginning of the lecture, but I forgot. There is a question which, there's a question which I have for you. Okay, this was something which I wanted to revise at the beginning of the lecture, but I forgot. So let it be, we will revise it in the end. This is one extra question which I wanted to discuss with you. It relates to communication of offer and acceptance. So let us discuss this. Read it first. Okay, you can pause the video, read it, and then we will discuss it. Okay, pause the video, be ready with your answers, and then I will discuss it. Come on. So are you ready? Did you pause the video? All right. X of Agra, let me write it over here. X of Agra sends a letter by post to Y of Delhi offering to sell his car for rupees 1 lakh. Now this letter is posted on 1st of January. The offer is given on 1st of January. It reaches Y on 7th of January. Now Y sends his acceptance by post on 10th of Jan and it reaches X on 15th of Jan. Did you write this properly? Let us go through the answers now. When is the communication of offer complete? Is this your answer? 7th of Jan? Very good, students. I'm so happy. When is the communication of acceptance complete as against the offerer X? 10th of Jan. Correct. All right. All the dates go cross. It is easy. Okay. All the dates go cross. And then the answer is, when is communication complete as against Y? 15. All right. By when can X revoke his offer? 10th. He decides to revoke on 8th. Is it valid? Yes, it is valid revocation, and he also sends it by a faster means of communication. By which date can Y revoke his acceptance? 15th. He decides to revoke on 14th. Is it valid revocation? Yes. Is your answer correct? This is exactly how it will be asked in the exam. Wasn't it easy? Yes. So if you got this answer correct, I'm so happy for you. Now in my next session, I have some homework for you. We have completed the entire unit. If we have completed unit 1, I have a homework for you. You will learn everything that we have studied till now. Take one day off. Don't watch the next lecture. Give yourself time to learn whatever we have studied till now. Then you will solve questions from the compiler. Solve means you don't have to write, but you have to write pointers. Like, if this question is asked in the exam, how will you frame the answer? So go through all the questions. In my next session, I will discuss each and every question from my compiler. I will train you on how to write the answers, how to frame the answers, what is to be written where. I will teach you all that, but first try it on your own. Let's see if you're able to apply the concepts. Okay. Now, this is the answer writing format. Okay, answer writing format. You will divide your answer into 4 parts. You will mention provisions, facts of the case, analysis, and conclusion. So give heading, underline that, leave the space, okay, leave this line. From the next line, you will start writing your provisions. Now, what will be included here? So here we will start by quoting the section number. You will mention name of the case law. If required, you can explain it. And you will mention only and only the theory related to that question. In facts of the case, you will write the question in brief. just explain it in your own words, or it is like a pressy writing. Okay, whatever question is given, just concisely write it in like 3 to 4 sentences. In analysis, you will provide solution. And in conclusion, you will conclude by 1 or 2 sentences. Hence, therefore, these are the words that you will use to start the conclusion. Hence, therefore, so, it is so concluded. From the above, we can conclude that. Okay, so this is how you will start your conclusion. Here you just need to end the answer. So how to identify what is to be written in conclusion? Let's go through that. Just a minute, I'll open the compiler. So let's say that this is the question. Okay, this is the question. Pratham applied for the job as the principal of a school. The school management decided to appoint him. One member communicated privately to him. This is the case law, Powell versus Lee. You will give the heading provisions. You will mention only the theory. Up till now, we have not discussed anything related to the question. You will write the theory. Because this question is a direct conversion of the case law into a question, you should mention name of the case as well as explain the facts of the case in brief with judgment. Otherwise, only name is sufficient. But here, because it is directly based on the case law, they have just converted the case law into a question. You will mention the name of the case law and you will also give the facts and judgment in brief. So here we will write the section number. We will mention the case law and the theory related to this concept. Then you will leave a line, okay? Mention facts of the case. Give the heading facts of the case. Give the facts in brief. Just write it briefly. You can use the same words from here, or you can write in your own words. In analysis, you will provide solution. Here also leave a line. Here also leave a line. Analysis will provide solution. And in conclusion, you will give answer to this question. Can Miss Shakuntala claim damages? So Miss Shakuntala cannot claim damages as the communication was neither by the school nor authorized person. How to frame conclusion? You will first answer, can she claim damages? No. Give one line of reason. Why can't she claim damages? Because the acceptance was not communicated either by the school or the authorized person. Sometimes it will be a repetition of what you have written in the analysis, but that is fine. This also is okay. Miss Shakuntala cannot claim damages, but I always prefer that students write why she cannot claim damages. That is also important. Don't worry, this is the first time that you will be attempting questions. I am there to guide you. First attempt it on your own. Make mistakes, no problem. Get confused. But when you discuss everything with me, all that will be clear. I don't want to start spoon feeding you where I give you everything ready-made. You try it on your own. You come up with the solution and then see whether your analysis, whether what you interpreted was correct or not. Okay, students? So let us meet in the next session. But revise. Keep your answers ready. Go through the compiler once and then we will discuss it in the video.